When you are managing someone's affairs under a lasting power of attorney, it's a huge responsibility, and I could probably talk about it all day. So rather than do that, I'd rather just share my 5 top tips for when you're starting out. So the starting point, top tip number 1, would be to go and see a solicitor, preferably someone that is a fully accredited member of the Solicitors for the Elderly, just so that they can talk you through the do's and don'ts, good practice. It's to get you off to a good start. If you are starting to look after someone's affairs, you've probably got a few concerns that need looking into, and they could also talk you through those issues that are bespoke to you. Because I think it's important to remember that we don't know what we don't know. And so getting some advice at the beginning can set you off to a really good start. My second top tip when managing someone's affairs for them is to understand the 5 statutory principles that underpin powers of attorney. The first one is that the starting point is always that the donor, and that is the person who is making the power of attorney, has capacity. If they want to make an unwise decision, it's their prerogative to do so. So if they decide that they want to sell all their belongings and give the proceeds to the cat's home, it might not be their best decision, but it's their prerogative to make it. Number 3 is that if capacity starts to diminish, then you have a duty as an attorney to provide them with as much information as possible so that they can still make their own decision. For example, if somebody asked me if I wanted a cup of tea, I don't have to think very much about that. But if somebody asked me to choose between investment A and investment B, I might need a bit more information to be able to make that decision. And as an attorney, you need to make sure you provide as much information as possible so they can continue to make their own decisions. And number 4, if you are making a decision for an attorney, you need to make that decision in their best interests. And finally, not only does it need to be in their best interests, but it needs to be the least restrictive of their rights and freedoms. So my number 4 top tip is to actually understand the difference between the 2 powers of attorney, because they are slightly different. So with a property and finance power of attorney, you could start managing someone's affairs for them whilst they still have capacity. Obviously, you have to have consent for all the decisions that you are making on their behalf. But with a health and welfare power of attorney, you cannot make any health and welfare decisions unless they cannot make that decision for themselves. And it is an important distinction. And also as a side issue, I think it's really important that you read the documents themselves, because in those documents, the donor may have put restrictions or advice that they want you to follow on their behalf when acting. And my final top tip would be rinse and repeat. It isn't a case of once you've done the above that that's the end of it. Your attorneyship journey, managing affairs for somebody else, will take lots of different turns. Their circumstances will change, and so you might need to go back to the beginning and retake more advice. And they are my 5 top tips.